All right, we'll start the day calling. This is Baxter County criminal case CR 2017-116, State of Arkansas versus Michael Cox. For reappearance here today. Mr. Cox reappears for a pretrial hearing. Are there any pretrial motions filed to be heard?
No, Your Honor. Mr. Cox has been in the Ozark County Jail. He was released in late July, and I believe that he's back in our jail now on charges that he's not yet applied to us on. But on the case number 17-116, there is no action to take today.
It's according to the scheduling order, it's for a reappearance on September 14th for a final hearing and it's set for jury trial during the week of October 23rd. All right, Mr. Cox, you may be excused. We have 2017-236, State of Arkansas versus Kyle Simons.
Yes, Your Honor.
Morning, Your Honor.
Good morning.
I'd enter my appearance on his behalf in this matter. He's already been arraigned. He currently has a failure to appear based on missing his attorney status date.
When was that? When did he miss his?
August 3rd. You're gonna have to show up August 3rd.
August 3rd.
We have it, this was just a review date with the bond forfeiture hearing is set for November 16th in this case. That's the dates we currently have, so we'll need to get him back on.
Your Honor, is the bond forfeiture, was that set when he failed to appear? Is that?
Yes,
Okay.
we set those. I was just looking to see when he failed to appear.
Prosecution thought August 3rd.
He had been set for trial. He was down for a trial during the week of January 8th.
Your Honor, can we leave all those dates in place?
We'll have to put him back in place. So it's put him back on the trial schedule for the week of January 8th. We got him down for a plea deadline on November 16th. We've got him down for, we'll put him down for pretrial on September 28th. So we're just reestablishing the previous scheduling order.
Here, give me sign yours.
All right.
I think the Public Defender's Office already has the discovery on the matter. I will get with them later today and retrieve that, so I don't think.
Pardon?
Anyway, I'll get with the state and get the discovery today, Your Honor. I don't think that'll be an issue.
All right.
And there is the outstanding failure to appear. We'd request that now that an attorney has entered their appearance on his behalf, if that could be recalled, Your Honor.
Your Honor, this gentleman's been missing for a month, Your Honor. He left
2
on
months.
August 3rd. I'm sorry.
I believe he's been missing for 2 months.
Oh, has he been missing for 2 months? I don't
Because
just
I
know.
issued the alias warrant. No, he was missing from time in June until July 16th. And then we got him back into custody.
Thank you.
We issued another alias warrant.
Yeah, Judge, I just don't want to let him go. I'd like to have a hearing on that or give him some sort of bonding arrangement. The man's entitled to a bond, I guess, even if he appears, but it ought to be more than what he's already posted. He's obviously not coming back to court.
Your Honor,
Let's go ahead.
no, hang on, Kyle. In response to that, Your Honor, I would agree with the state. We need to add an additional requirement to the bond. It seems like an ankle monitor would be appropriate to ensure his reappearance in court and/or location in the event he does fail to appear. Because these are not allegations of reoffending or anything like that. It's just getting him here to court, and he's now hired an attorney, and I think he's going to engage this properly, and I think the ankle monitor would address the concern the state has.
But that's the whole purpose of the bond in the first place, was to get him here to court, and secure his presence in court. If it's not doing it, yeah, as I say, I've issued 2 alias warrants on this individual.
Judge, and I've yet to hear an excuse for his non-appearance on either one of those 2 dates. As far as the state's concerned, this man is a flight risk. He's a failure to appear risk. He doesn't seem to be going anywhere, but his problem is he's not coming to court.
Your Honor, I thought I only had one.
Hang on, Paul.
Well, I'm trying to find something, this is the problem. I'm trying to find something that tells me what the bond previously was, so that I can work off that.
Judge, the first affidavit says $5,000.
Okay. Yes, that's back in June of 2017. All right. Court will withdraw the alias warrant and let that go by the board, but I'm going to reassess his bond at $20,000, cash or profession.
Thank you, Your Honor.
All right.
Reappear May 21.
Kyle, I'll try to get over there today to see
His
you.
next appearance is September 28th.
I'll try to come over today and see you.
Thank you.
All right,
I
you may be
abstain.
excused. Pardon?
I have to stay in here.
No, you have a bond of $20,000 at this point.
Can I call a bondsman?
Yes, but we still have the collateral issue we talked about. Let me work on that, okay?
And if you bond out, your next appearance in court is September 28th. And if you don't
Yes,
show
Your
up
Honor.
for that, you can probably expect to stay in court, in jail until the trial date in January.
Yes, Your Honor. I won't miss again. Thank you.
Two 2017-326, State of Arkansas versus Chad Merriman. This Mr. Merriman's reappearing for attorney status today. There's a scheduling order in place that has him for trial in February of 2018. Plea deadline of February 22nd, 2018, a pretrial January 25th, 2018, and he's down for a review hearing on November 16th. Mr. Merriman, have you made any arrangements to have an attorney?
Got the paperwork filled out and sub from the public defender's office. I guess Pedigo dropped.
Pardon?
I guess Pedigo dropped me, and I have the paperwork here for the public defender's office filled out.
All right. Now, Pedigo hasn't worked for this office, worked for the public defender's office here for about 3 years or 4 years. It's a substantial period of time. Oh, I see. Well, you turn in that paperwork, I'm gonna get that turned in. As I say, your case is already set for trial. It's already on a scheduling order that has the dates. Your next appearance in court will be November 16th.
Yes, Your Honor.
All right. All right, you may be excused. 2017-332, State of Arkansas versus Michael Glavish.
Your Honor, I believe that Mr. Glavish is here. He is a client of our office to be put on this court schedule. Your Honor, he appeared in front of Judge Putman last week, and Mr. Bailey entered a plea of not guilty on his behalf.
Okay, so he's been arraigned.
Yes, Judge.
The scheduling order has him next appearing in court on November 16th. The scheduling order includes a jury trial has been set during the week of February 26th of 2018, plea deadline February 22nd, with a pretrial set for January 25th of 2018, and a reappearance on November 16th. So your next day in court will be November 16th.
Yes, sir. I was wondering if I'm able to get a possible bail reduction?
If you're able to get a what?
A bail reduction?
Your Honor, the notes from the file from last week reflect that he had a parole hold. I don't.
They lifted the hold last night. They lifted my parole hold last night. I take care of my grandmother, and I work 7 days a week. I'm just trying to get back to work, take care of my grandmother. She's got Alzheimer's.
Judge, the state knows this gentleman was on parole when he committed this offense. I thought there was a parole hold on him. We're checking to see.
Bond is set at $2,500.
Pretty reasonable bond.
Yeah, cash or professional. So
Yeah,
if
they
that's
don't-
been listed, that's the bond. All right?
Michael, do you understand what the court has said?
He said that the bond is $2,500.
Right. The bond is $2,500, so if your parole hold is in fact lifted, then you can bond out.
Yes, I
For that
was wondering if I
amount.
can get a bond reduction, if at all possible.
Well,
State would oppose that, Your Honor. This man was on parole, and if you review the affidavit, he's not following his parole.
based on your standard, on the, what we usually do in matters of this type, this isn't the crime of the century by any means, but you have a past criminal history, and that $2,500 cash or professional bond is a minimal bond, so that'll be the bond. All right?
Thank you very much, sir.
All right.
When's my next court date, sir?
November 16th.
Thank you very much. (2017-162), State of Arkansas versus Edmund Crow.
Honor, I saw Mr. Crow. He's a client of ours also in my office yesterday, so I'm not real sure why he's back in jail. He has a new charge, or do you know, Kerry?
Say it again.
Do we know why Mr. Crow is back in jail?
He's got new charges, Your Honor. He's been arrested on some new charges. We haven't received the paperwork.
But he's
yet.
not for arraignment yet.
I don't think we've got the paperwork back in our office.
All right. Mr. Crow, your status on your old case, which is this one, 2017-162, is that you're down for a pretrial hearing today. Are there any pretrial motions or any hearing to be held today?
Your Honor, in view of the new charges, and there's no further action to take today, I would remind Mr. Crow that when these charges are actually filed, that if he wishes us to represent him, he will need to fill out a new application, Your Honor.
Did you understand that, Mr. Crow? You need to fill out a new application to the Public Defender's Office in relation to the new charges. The court's, while he's in custody, the court's going to put him down for to reappear in front of Judge Putman on September 7th. Just simply that should be for arraignment to give him a chance to address the new charges as promptly as possible. So I'm showing him on our charges. There's no pretrial today. His next appearance in court then is, in this case, is September 28th, which is the plea deadline, with a jury trial set for October 23rd. But I'm putting him down to reappear in front of Judge Putman on September 7th to get him arraigned on the new charges. All right? Mr. Crowe, did you understand?
Yes, Your Honor.
All right, you may be excused. Court will call 2016-400, State of Arkansas versus Rebecca Biniarski. You're appearing here today for purposes of changing your plea on the charges, is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Cooper. Is that also correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with your attorney?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes, sir.
On the charges against you of breaking or entering 2 counts, both Class D felony and theft of property, a Class A misdemeanor, and then a theft by receiving a separate Class A misdemeanor, how do you now plead?
Guilty, Your Honor.
You're entering this plea of guilty pursuant to the agreement that's been worked out for you, and that agreement is in writing in the document I'm holding up called a plea statement.
Yes,
Have
sir.
you read through this plea statement?
Yes, sir.
And having read through this plea statement, do you recognize that, do you feel you understand what's contained in the plea statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
When you, as they're set out in here, the rights you're giving up are the right to a trial by jury. And when you give up the right to a trial by jury, you would also at that trial have the right to have an attorney represent you and assist you throughout the trial. You'd have the right to confront witnesses at that trial, and you'd have the right to appeal afterwards. All of those are rights that you're giving up by pleading guilty here today. Do you understand that?
Yes, sir.
And understanding what rights you're giving up here today, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes. Yes,
Has
sir.
anybody in any form or fashion forced you into this plea?
No, sir.
As you plead guilty here today, are you acknowledging or admitting that your participation in the criminal activity charge?
Yes, sir.
Are you admitting that on or about November 6th of 2016 here in Baxter County, that you entered into a shop building on someone's property and took a
Your Honor, that affidavit is very poorly written. May I give you the factual details of that?
you took an item of personal property from that shop building?
She did not do that on that day. Her boyfriend, Tommy Gaddis, entered that building with another individual. They stole items out of that, including a winch. That winch was brought back to Tommy Gaddis's home that he shares with this lady, and she took it knowing that winch was stolen. She took that winch and pawned it at a pawn shop here in town. That would account for the first theft of property, that is the theft by receiving.
The theft by receiving.
Yes, sir. The two breaking and enterings, the first breaking and entering occurred on November the 15th, 2016, here at 2169 Highway 62 West, where she said she participated with Dean Thompson in entering that home, that storage building, although she claimed she didn't take anything. And then there was a incident on 12/2/16 where she would have entered an abandoned residence located at 2471 Highway 62 West, where she took an antique car and some sort of game board. That's the basis of those charges.
Okay, so what you're willing to admit to is that on, assume it's on or about November 15th, in that time frame, that you had in your possession an item of stolen, a winch that was stolen,
Yes, sir.
and you had that in your possession.
Yes, sir.
Secondly, you're admitting that on or about November 15th, and then, well, the other day was December
Second.
2nd of 2016, you had in your possession, or that you went into 2 different structures, is that correct? And from each one took,
Judge, I don't think she took anything from the
items,
storage building.
items of a misdemeanor value from one or both, one of those? Is that right?
Yes.
Is that what, are you
Yes.
admitting that you did that?
She acknowledges her involvement in this activity, but to the specific breaking and entering, I think her proper plea to the breaking and entering charges should be one of no contest instead of guilty. And I could go into a long protracted statement about that, but I'm not going to. But we get to the same point, but I think Mr. Chisholm's already stipulated facts which she will not dispute
Okay.
on the breaking and entering only.
Okay. With regard to the, so, with regard to the actual taking of property on or about November 15th, are you admitting that there's a misdemeanor amount of property? This says an
Yes, sir.
antique metal car and a Chinese checkerboard.
Yes, Your Honor.
Okay. So there was some
Yes, Your Honor.
relatively inexpensive stuff that you took
Yes, sir.
on one occasion. And then there was, that you had in your possession, so you're admitting to those 2
Yes, sir.
misdemeanor charges.
Yes, sir.
Now, on the breaking or entering charge, are you wanting to change your plea to no contest?
Yes, Your Honor.
Okay. Now, in that regard, you understand that the same questions apply in on a no contest plea that I already asked you. You understand that by pleading no contest, you're giving up your certain constitutional rights that we went over?
Yes, sir.
And you're entering this plea, are you entering the plea of no contest freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into that statement?
No, sir.
Based on that, the court's going to accept the plea to the no contest charge, and will call upon the state to, again, state the basis the state could prove in court for the charging the 2 counts of breaking or entering.
Judge, the Mountain Home Police Department received a complaint of breaking and entering, theft at a building used for storage located at 2169 Highway 62 West. While being interviewed, Ms. Benarski on 12/01/2016 admitted that she entered the building at the approximate date in the complaint with a Mr. Dean Thompson. That is, we have the state is in possession of a recorded statement, a recorded video of that. During that same interview on 12/01/2016, she would have admitted to entering a residence that she described as an empty abandoned house. Again, this is on video with cream-colored brick exterior that was next to the business known as Supply Solutions. While in that house, she admitted she stole an antique metal car and a Chinese checkerboard.
All right. Based on those statements, the court's going to find that the defendant has freely and voluntarily entered a plea of no contest, and accept that plea, and with the statement of the state, find her guilty of 2 counts of breaking and entering, and on the theft of property, the court, where she pled guilty, the 2 counts of the theft by receiving and the misdemeanor, and the taking of theft of property misdemeanor, the court is accepting that plea, finding her guilty of 1 count of theft of property, Class A misdemeanor, 1 count of theft by receiving, Class A misdemeanor. And at this time, pursuant to the agreement in this case, the court will proceed with formal sentencing the defendant on both of the breaking and entering charges to 6 years of supervised probation based on the subject to the standard terms and conditions of probation on each of those. On the 2 misdemeanor charges, the court is sentencing the defendant to 12 months of misdemeanor probation, subject to the standard terms and conditions of misdemeanor probation on each of those counts. In addition, the court, all those sentences are to run concurrent with each other, and the court is imposing a $200 in court costs, a fine of $2,000, the statutory DNA fine of $250, boogie administration fee of $20, a public defender fee of $125 and $75, and imposing restitution on the defendant in the amount of $300. All of those amounts are due and payable as a term and condition of the defendant's probation. Payments are to be made in regular monthly payments of at least a minimum of $100 per month, beginning within 30 days of this date and continuing every month thereafter until paid in full. The court, in placing the defendant on probation, has reviewed and is now signing the written terms and conditions of probation, which are attached to this plea statement, making those an order of this court. The court notes that Ms. Briniarski has herself signed the acknowledgement at the bottom of that page, indicating she has read, understands, and will comply with the terms and conditions of probation. I'm directing that she name the probation officer